Dear students, good morning. Today we will discuss about the Karnataka's recent draft bill on fake news. So recently the Karnataka misinformation and fake news prohibition bill, it has sparked a strong response from civil society, media and legal experts. At its core, the bill claims to counter the menace of misinformation and also the fake news. That is the ideal purpose of the bill. However, it raises a deep concerns about censorship and state overreach in implementation of this bill. So it raises a deep concerns about the censorship, state overreach and also the violation of the constitutional rights such as freedom of speech and expression under Article 19(1)(a) of the Indian Constitution. So in this today's discussion, we will explore the key features of the bill and why it is being criticized and the relevant judicial precedents and what should be the way forward in tackling the misinformation in a democracy. First, let us see the key provisions of the bill. First, we will try to see what are the various provisions of the bill. The first one is establishment of an authority, because the bill proposes an authority to identify, classify and penalize the misinformation. So this authority will be headed by the state's information and broadcasting minister. It is headed by Information and State Broadcasting Minister along with some other government appointed officials and lawmakers. So this actually raises questions of the bias, lack of independence and also there is a possibility for the political misuse. And the second thing is actually the broad and vague definitions. Because in the bill, the fake news is defined as the false or inaccurate reporting, editing that distorts the facts, and purely fabricated content. But the problem here is the misinformation is also defined as the knowingly or recklessly spreading of the falsehoods. So the exceptions are vaguely granted for the religious ceremonies, satire and artistic expression, but no clarity on who decides the boundaries. So it is very difficult to define such a kind of the words like fake news, misinformation. It's very difficult and the bill does not addresses any concern to give certain kind of the proper definitions to these terms. The third one is punitive provisions. Actually, the bill having different provisions to penalize the people who are propagating misinformation. So some of the provisions are there is a fines up to 10 lakhs is there and imprisonment up to 7 years are there, or in some cases maybe both also will be applicable. So these punishments are actually disproportionate and draconian for a law that lacks actually the precise definition. If you have an exact definition, the people have a clarity what to do and what not to do. But when you don't have the proper definition for the terms like misinformation or some other thing, so those kind of the vague with those vague definitions and placing this type of the punitive provisions is actually not a great thing to do. An important thing is criminalizing opinions. Actually, the bill seeks to prosecute speech that allegedly goes against the feminism or Sanatan Dharma. This leads to dangerous possibility of ideological censorship. That is very important. Ideological censorship under the pretext of maintaining morality or culture. So here the bill is slightly inclined towards the Hindutva ideology. That is also one of the concern. Now let us see what are the legal and constitutional concerns. So there are some legal and constitutional concerns as well about the bill. and just we will try to discuss few of them. Number one, the Supreme Court guidelines on the Shreya Singhal case in 2015. Actually, in its landmark judgment, the Supreme Court clearly says that Section 66A of IT Act, and the Supreme Court struck down for being vague and chilling free speech. So the Section 66A of the IT Act was struck down. The court also emphasized the importance of clear and proximate connection between speech and hateful speech. So without any clarity and without any proximity, we cannot take an action in the name of the person is having the hate speech. So there should be clear and proximate definitions and connection should be there. The Karnataka bill actually ignores this principle. That's the problem. Because leaving terms undefined and open to arbitrary interpretation, and based on that interpretation, they are going for the punitive actions. So that is not a great thing to do. And the second important judgment in this concern, you can consider is Bombay High Court verdict. So the Bombay High Court verdict on IT rules in 2024, it clearly says that regulating digital news media via vague executive rules, it violates the freedom of speech. And Justice Gautam Patel clearly noted, every attempt to whittle down a fundamental right must be resisted root and the branch. So even the Bombay High Court also is not interested, and it is very clear that just in the name of the IT rules, you should not regulate the digital news media channels with respect to vague executive rules. The rules should be very clear and precise. And the third one you need to understand was the fundamental rights itself at risk, because we know that Article 19(1)(a), the freedom of speech and expression, and right to life and personal liberty, Article 21, because it is restricting your freedom of speech and the punitive actions are against to the right to life and personal liberty. So the doctrine of proportionality actually, which is required. So the doctrine of proportionality. The doctrine of proportionality, which requires that restrictions on rights must be narrowly tailored. It should not a broad way. So these are the different constitutional concerns. With respect to the legal cases, you can quote these two in the examination, that will be better. And with respect to the constitutional provision, you can name these two, that will be much better. Now we will see that what are the various practical concerns are there for this bill, because still it is in the drafting stage only, right? So the problem here is, the first and foremost thing is, India itself has almost all 700 million smartphone users are there. So, and one more thing is, the Karnataka itself is among the top states in the internet penetration, and it is very much home to the Bengaluru's tech hub. So can a government appointed body monitor, verify and censor such a volume of the content without violating individual rights is a big question mark. The second practical concern is effect on innovation and startups. Because Bangalore is itself an India's startup capital, the fear of surveillance and censorship actually may chill the innovation, especially in the digital media, the content creation and tech communication platforms. The third important practical concern is selective enforcement possibility. Selective enforcement. So like the sedition or UAPA provisions, such a vague law could be used to target dissenters, critics, journalists and also political opponents. So these are the various practical constraints are there. And also it is very much clear that the legal experts also, they call it a law of the bad faith that gives the state unchecked powers. Just because of this, the state is getting enormous powers because of the vague definitions. And the media organizations say it very clearly that it opens the door to the state censorship under the guise of the protecting truth. It is not a great thing to do. And even the civil society fears it will weaponize the misinformation laws to silence the critic and to silence the dissent, especially of those in the power. So those are all the original practical concerns which should not be ignored. And let us see what should be done at this context. We have few options are there. Number one, we must increase the digital literacy, and we need to take enough initiatives to increase the digital literacy, educate students and communities to distinguish fact from the fake news, and promote critical thinking and digital hygiene starting from the school curriculums. The second thing is voluntary fact checking. Because if you can check the fact voluntarily, it will strengthen the independent third party fact checking institutions with the transparency and credibility. Because it will encourage the social media companies also to partner with the civil society fact checkers, but it will not rely only on the government. So encourage the voluntary fact checking mechanism. And the third one is public dialogue, and create some consultative forums with the experts, technologists, civil society, and legal scholars before making any laws. You need to take the consensus, you need to go for the vivid consultations before forming this type of the laws. Avoid one-sided or politically motivated legislations, because that is not a great thing. And finally, as a conclusion, we can say, because I'm telling conclusion in every video just because of the reason that you can understand how to write a conclusion in the mains examination. For this article, you can write a conclusion in such a way that the Karnataka fake news bill is not just bad in the drafting, it is dangerous in the spirit. It reflects an authoritarian mindset wrapped in the language of the protecting truth. As the editorial rightly states, the battle against misinformation must be fought through education, digital awareness, and participatory governance, not through the draconian laws that threaten our constitutional freedoms, which was granted by the Indian Constitution. So, we need to understand, not a draconian law. The bill needs to be binned and it needs to be reviewed, and consultation has to be open, and the draft needs to be revised. Then only it will become a good bill to curtail the fake information. Thank you.